Interestingly, see how Sheikh Abdullah puts it. He says the most powerful argument which can be advanced in her favor is that Pakistan is a Muslim state.
Yes.
And a big majority of our people being
secular...
Muslim, the state must succeed to Pakistan. But then he says, this claim of being a Muslim state is of course only a camouflage. It is a screen to dupe the common man so that he may not see clearly that Pakistan is a feudal state in which a clique is trying by these methods to maintain itself in power.
Absolutely. She is right.
After that, actually, we were reading at it goes on to about 1466, where he specifically speaks about the importance of the affiliation with India and accession to India, because he speaks in terms of, first he speaks about the Indian Constitution.
That's correct.
Second, it's very important from a historical perspective. Sheikh Abdullah refers to the land reforms which were taking place post the First Amendment and the other amendments which took place to the Constitution. He says Pakistan, on the other hand, is a feudal state.
That's correct.
And therefore, our interests would not be protected in a feudal Pakistan as compared to an India where land reforms were taking place. Then he refers to the fact that, India has, of course, the access to the seas and therefore a better, as an economic powerhouse, for us to carry on trade through the auspices of India. And this really continues until PDF page 107.
I didn't want to refer to it because it would take too long. Two, it's the background, but we are dealing with the temporary provision. That's why I didn't refer to it. But all that is very important. The reason is simple. Ultimately, what did J&K do? The people of J&K gave to themselves the constitution, just as the people of India gave to ourselves this constitution. So central to all this is the will of the people. And therefore, you'll have to compare it to the...
Very interestingly, see how Sheikh Abdullah puts it. He says the most powerful argument which can be advanced in her favor is that Pakistan is a Muslim state.
Yes.
And a big majority of our people being Muslim, the state must succeed to Pakistan. But then he says, this claim of being a Muslim state is of course only a camouflage. It is a screen to dupe the common man so that he may not see clearly that Pakistan is a feudal state in which a clique is trying by these methods to maintain itself in power.
Absolutely. She is right. The point I'm making, Mullahs, ultimately, what's the essence in this matter that your lordships are hearing? The will of the people of a state where the Executive Act of the Union of India, which decimates the will of the people. That's the issue before you. That's what your lordship, because all the three acts of the Union of India are executive acts. 356 deletes the proviso of Article 3. That's an executive act.
Mr. Sibal, look at the foresight of the speaker. He says, these days, economic interests and a community of political ideals more appropriately influence the policies of state.
Absolutely, absolutely.
He had this vision in 1951 when he was speaking about the importance of economic interest, which is what the world is talking about today.
Absolutely.
In a globalized world.
And in that situation, the ruler had no choice. Absolutely no choice. So, the point I was making is that we are now dealing with three executive acts. One, the 356. Two, change of interpretation in the definition of Constituent Assembly under 367(1). And the abrogation. These are all executive acts. The will of the people is not considered at all. That's the question. Can you delete provisions of the Constitution by an executive act? Can you decimate the Constitution by an executive act? Can you change the Constitution by an executive act? We're not talking about legislation here. We're not talking about parliamentary legislation. That comes after these executive acts, Mullahs, are implemented. That's the question. That's the... You can't change the Constitution of India as applicable to Jammu and Kashmir by deleting Article 3, the proviso to Article 3. You can't do that through an executive act. You can't change the definition, Malaj, of the legislative, of the Constituent Assembly as legislative assembly through an executive act. Just then I'll come straight away to the issue, Malaj, 1921.
1921.
Yes, PDF, Malaj, 562. Here I would like to point out that the fact that Article 370 has been mentioned as a temporary provision, the Constitution does not mean that it is capable of being abrogated, modified, or replaced unilaterally. Kindly mark the words unilaterally, which is exactly what has happened. In actual effect, the temporary nature of this article arises merely from the fact that the power to finalize the constitutional relationship between the state and the Union of India has been specifically vested in the Jammu and Kashmir Constituent Assembly. That's how Malaj Parliament understood it in 370. That's how the state understood it. It follows that whatever modifications, amendments, or exceptions that may become necessary, either to Article 370 or any other article in the Constitution of India in their application to Jammu and Kashmir, are subject to decisions of this sovereign body. Since a good deal of confused thinking and uninformed criticism is indulging us in the interest of, I would like to point out here that the Constitution has confined the scope and jurisdiction of the Union powers to the terms of the instrument of accession, with the proviso that they may be extended to such other matters also as the President may by order specify with the concurrence of the Jammu and Kashmir Constituent Assembly. The special problems facing the state were thus taken into account, and under the Constitution, the relationship approximated to that subsisting under the instrument of accession. The Constitution of the Indian Union therefore clearly envisaged the convening of a Constituent Assembly for the state of Jammu and Kashmir, which would be finally competent to determine the ultimate position of the state in respect of the sphere of its accession, which would be incorporated as in the shape of permanent provisions of the Constitution. This briefly is the position which the Constitution of India has accorded to our state. I would like to make it clear that any suggestions of altering arbitrarily the basis of our relationship with India would not only constitute a breach of the spirit and letter of the Constitution, but it may invite serious consequences for a harmonious association of our state with India. The formula evolved with the agreement of the two governments remains as valid today as it was when the Constitution was framed, and reasons advanced to have this basis changed seem completely devoid of substance. In arriving at this arrangement, the main consideration before our government was to secure a position for the state which would be consistent with the requirements of maximum autonomy to the local organs of state power, which are the ultimate source of authority in the state while discharging obligations as a unit of the federation.